Good afternoon, everyone, and welcome to Fridays with Keenan's Cutting Edge. My name is Jenna Labor, and I will be your host as we explore the dynamic world of Don Keenan's trial philosophy, the cutting edge. Those of you live with us this afternoon have the opportunity to ask questions and interact with our speaker. If you have a question, please type it into the comments section below and we will be sure to address it. Episodes are released each week following the live broadcast, so be sure to hit that subscribe button and click the alerts icon so you do not miss an episode. Today, we have Brian and Elizabeth, or BB Sanford, out of Dallas, Texas with us to talk about their recent smashing victory with a $70 million verdict in an employment case. You guys must have punitive damages down there because I don't think that has ever happened in Washington state in an employment case. Brian and BB practice employment law together in Dallas, and we will put their contact information in the description below so you can contact them directly after this episode with any questions about this case or Edge in general. Brian and BB, share with us how you used Papa Don's teachings to obtain such a monumental outcome for your client.
Thanks, Jenna. Hi, everybody. So glad to be here. It's a great honor just to be on this podcast, be part of such a wonderful organization. So we're here to talk about our verdict. It was a telecom company that discriminated against Black technicians, engineers, and then because of their race. And then when they opposed it and reported it, retaliated against them and against a white engineer who stood up with them. And we represented them, took it to verdict, and best jury in the world gave us a $70 million verdict. Gave 10 individuals $7 million apiece. So it was all Edge. Edge works in employment cases. We did Edge from the beginning to the end, to the best of our ability. I'll talk about how we started. Two individuals came in, a Black engineer and a white engineer about 2.5 years ago, came into our office and said that there was widespread discrimination in the telecom company. The subsidiary was called Glow Networks, and the parent was CSS Corp. And all of the business cards, all the letterheads, all the signs, everything was CSS Corp, but the paycheck said Glow Networks. So we sued both of them. They had a tape recording of a manager saying, don't lay off, that HR had told the manager, don't lay off white people. So that was like a smoking gun that we had. We filed it initially as a class action. We didn't know how many people were involved and how across the board it was. Our people worked in the Dallas office, and it was a national, actually global. The parent company was global. Parent company is based out of India. It's global. So we filed it as a class action in federal court in the Eastern District of Texas. Judge Sean Jordan was the judge. So the courthouse is North Dallas, Plano. And we learned early on in the litigation that the judge was not in favor of granting a class. We could tell by his decisions. He more or less, we got the hint in the discovery. So what we did, we had enough discovery, and this discovery was limited to Dallas. So we had enough discovery to learn the identity of the employees, and we contacted them, and a total of 14 employees signed up to be named plaintiffs. So instead of a class action, we had 14 plaintiffs, all Black, one white. Several were born in Nigeria. So we had African and African American, and they all self-identified as Black employees, except for the one white engineer. So we proceeded, we did what we do. We started with edge concepts from the very beginning. We did our jury instruction from the beginning. We did our opening statement from the beginning. We did our hits from depositions in depositions, the hits, the way you get hits in depositions, and prepared each of our witnesses, all 14 witnesses. I take it back, 13. They forgot to depose one of the witnesses. Oh, yeah. So 13 of the witnesses, we went through all of the Keenan Edge witness prep, all steps with each one of them.
It was a lot of days involved.
Yeah, so Edge is hard work, but worth it. And each one, of course, as you've experienced whenever you use the witness prep, felt so confident and really changed it. Witness prep changes people for the better. So each one of them felt a whole lot better about themselves and about the case and about where they were at and confident. So that was awesome.
Yeah.
And they filed a motion for summary judgment, which if you've done any employment cases, they're ubiquitous. They always file them. So, but what was unusual in this case is it was only a partial summary judgment motion, not for the whole case.
Mm-hmm.
And usually it's the whole case. So they just filed for maybe because we had a tape recording and they just saw the handwriting on the wall. I don't know. But they filed for hostile work environment to be dismissed and constructive discharge because several of our engineers left because it was so bad. And so we had constructive discharge claims, hostile work environment claims, failure to promote, demotion, and termination. Some were terminated outright, some were laid off. The judge granted the summary judgment in full on the Wednesday before trial. So all of our hostile work environment, gone. All the constructive discharge, gone.
Four of our clients,
gone, including one who had circulated a petition among the engineers to try to then take it to management to say, look what's going on, and was fired 2 days later. His retaliation claim, gone. That will be a subject of appeal.
Mm-hmm. That's a good claim.
Yeah. So gone. And then, so the trial. Monday, the Sunday before the trial, BB was training for a marathon. It was icy in Dallas. She slipped on ice and broke her ankle. Spent like 8 hours in the hospital. I thought they was going to have to do surgery, but not then. Delayed. She was not going to miss this trial. So she came in on crutches. And the first day on crutches and just endured the pain. We were allowed, we knew it was going to be a 2-week trial. We were allowed 45 minutes of jury selection, up from 20 minutes. The judge originally said we only get 20 minutes, but then he allowed 45, and that was going to be heaven, because then at least I could do, an edge jury selection rather than a 17-minute jury selection, of kind of a full, and we did. So it was, the jury selection process was great. We were able to identify several people that, we got, the panel was 37 individuals, only one Black panelist, which had been my experience in that trying cases up there. I had told my guys, they were all men that we represented, that we could probably expect about maybe one Black panelist and not likely to get that person on our jury. And of course, they were very defeated about that. But this judge was very good on strikes. for cause.
Mhm.
So we were able to get strikes for cause on, I think, 8 people
8.
out of 37. And there was an African-American panelist, number 21. We were able to get to her. We were all ready for a Batson challenge. The other side didn't strike her.
And we found people are pretty vocal these days about their racist, biased beliefs. They're pretty straightforward, and so that was helpful in some of the strikes for cause. People would they would truly throw it out there.
Yeah, it's different from 10 years ago where people would keep their crazies inside and not talk about their biases quite as much. And it's really kind of nice now because they were just free. So we had one individual that basically came up, this was good because the judge, after dismissing the panel, would bring up anybody we wanted to strike for cause for individual questioning in front of the court without anybody else being there. I love that process. And so one individual openly admitted, look, somebody's talking about Black Lives Matter. Another person's talking about
George
Floyd.
Ahmaud Arbery.
I can't deal with this. It's February 7. We're 7 days into Black History Month. I don't know if I'm going to be able to survive the whole month. And you want me to sit through a discrimination trial, Your Honor?
Just can't do it.
So we said, thank you for your honesty. We appreciate that. Thank you for your honesty. There's 2 or 3 people just like that. That we haven't been seeing that in 10 years ago. So we were able to get a lot of biased jurors off, some readily admitting that they just could not be fair. And then we were allowed 3 strikes, 3 peremptories apiece to sit 8. And we got a great jury. We got a great jury because of, well, I guess a combination, but for sure, edge voir dire works. So we got a great jury, and we were so thankful that the judge gave us good cause strikes. So that was great. We lost 1 juror immediately because of childcare, and the judge let her off for hardship. Another good thing that the judge did is anybody that was not getting paid by their employer, he did everything he could to let them off. And we were fine with that because we had enough good jurors. They were all happy. Happy jurors got paid, happy to be there. Our jury was happy to be there. It was a great experience. They loved it.
They were doing Bible studies together. The trial went over Valentine's Day. One of the jurors bought like heart-shaped donuts for everybody. At the very end, they gave out little trophies to everybody. So like one person was like Den Mother. One was like the baker of the group. One was the early riser award. So they really bonded on the jury. They loved being there.
The baker was the single male juror. So we ended up with 1 male juror, 5 women, 6 women, 1 male juror, it was 7, and 1 African-American juror and 6 white. And they were great. So, and they were, I would say, at least half or most of them were conservative people. So edge works across the board. So we did opening statement. Opening statement was pure advanced opening statement.
And we focus grouped it several times. I'm sure a lot of the Texas people saw it several times in our focus group. So we focus grouped the opening statement many times to make sure it was just how we wanted it to be.
BB did the opening statement. I did the jury selection. BB did the opening statement.
Yeah.
And
we got our statistic in.
We got all of our statistics in.
Yep.
We got 4 statistics. We had the 1 statistic in the opening statement.
Yeah.
And then we started with our expert. We decided that we were going to set the stage and we could get most of what we wanted in from the first part of our opening statement through our expert. We used an HR expert. And so, we set the stage on how big is the problem? How do you know the problem is big? Well, there's statistics. And in fact, we still have the picture of our poster where I wrote the statistics on the poster made the front page of the Dallas Morning News because when we took our picture and we gave it to the morning news, it has that. Our guys were holding that up, but it was, I still remember the statistics. 46% I had written on there of all people who saw a workplace violation and did not report it said retaliation was the reason. 50% of all people in the workplace have either seen or experienced workplace bullying. 75% have seen or experienced retaliation. 4,200 claims of retaliation are filed each year in Texas. Those were our statistics that all came in.
Yeah.
No objection, no Dalbert, no nothing.
Yeah.
It just came in. It was so wonderful. And it set the stage for foreseeability, preventability,
Rules.
then the rules and the items that show that the rules. How do you know the items are followed? If you just follow these steps, then there will not be retaliation. There will not, it will be prevented. So all of that was laid out. Our expert we did not have the expert read depositions. We did not have the expert look at any evidence. We just said, assume that the latest live pleading is 100% truthful. And if the jury believes the facts that are in the live pleading, then you can give us an opinion. Yes. And it's not for you to decide if those facts are true or not. You just assume. And of course, on cross, they tried to beat her up saying, well, you don't know if these are, no, that's for the jury to decide. Well, if it's false, then if that's false, then okay. But I'm just telling you what the standards are for the industry in HR. And here's what you should be. And if these are true, then the root cause is failure to monitor. And if they had monitored, then they would have supervised, and it's failure to supervise. It's a system failure. And if these aren't true, well, then, okay, that's for the jury to decide. So she came off very well. And then after that, we put on the white engineer, to be brutally honest, because we had 6 white jurors and he's going to, here he is white and he's standing up. So he's adding credibility to the black engineers. So we put him on and he laid it all out and said, here's what I saw. And what he saw was that black engineers and technicians were being treated differently. They weren't given the same breaks. They weren't allowed to use their phones the same way. They were, at one point, they were predominantly, we couldn't say everybody, but mostly black employees were huddled into 2 major rooms, and in which they had surveillance cameras looking down directly on them.
They assigned the seats to the black employees and they only had cameras on the black employees to make sure they were doing whatever. It was the stereotype that they were just lazy. And so you had to watch them because non-blacks are not going to be lazy. If you had Hispanic, Asian, white, Indians, only the blacks are going to be lazy, and we have to watch them because they're going to take long breaks and they're going to, or worse, steal or something. So he explained that. Then there was problems they promoted him, a white technician engineer, on up a couple of steps. And then he wanted to bring on a couple of the good black engineers, and he tried to do that. And before long, he sees the discrimination, speaks up about it. He gets demoted, and so do his back down 2 steps, and so do the 2 people he wants to bring up. And of course, they all get replaced by non-black persons. They quit based on the demotion. The judge allowed all that to stay. So what we got is anybody that was terminated or demoted or failed to be promoted, we were allowed to keep, but no hostile work environment. However, all the facts related to hostile work environment came in. You can't keep it out. It's all related to the discrimination. And at the end of the day, the jury is not thinking, okay, is there going to be a question on hostile work environment or not? They're just looking at, was there discrimination or not discrimination? There was discrimination. Was there harassment based on retaliation or not?
It's there. We did not use the word hostile work environment. I think we even had a limiting where we couldn't use it, but we didn't need to. It was all there. The jury got it. They're thinking hostile work environment.
There was spreadsheets too. There was a couple. It's a project-based company, and so when the project was sort of winding down, they were going to do layoffs. Well, the original layoffs that they had is they had a spreadsheet of all the current employees and all the races of the employees. Well, 55% of the employees that were slated to be laid off were Black. Only 8% were of the Asian category, and that's where South Asians like Pakistanis and Indians were. And so it was incredibly disproportional. And they said, oh, it's because all of the Black employees were low performers. And because how the company rated the performance of the different employees, it was slated against the Black employees. So they were known as low performers when they were really high performers. And we were able to show that and had other people show that. And then when they had a new project that they were bringing people back on for, it was only Asians, people that were brought back on. Zero Black, African-American employees were brought back. So that was another big piece to the discrimination.
A big underlying piece that drove this is the Asians were from India. So the Indians, there was a pecking order. At the top are people from India. In the middle, you're white. At the bottom, you're Black.
And we drew that.
We drew triangles.
We drew a social hierarchy triangle of how it was.
In fact, we had as a pyramid at the top with the CEOs and the C-suite, and then
they were all Indians.
And
they were
then
from
white
India.
was all the middle. HR is white. Middle managers were white and Indian.
No Black managers.
No, and then everybody's the.
Then you had tier 1 and tier 2s, and at the bottom, tier 2s were majority Black. Hardly any were tier 1s. None were above. We have a question.
Oh, parts of which of the
Which parts of the pie were you able to hit on?
We can't get on the podcast. We can't get into secret sauce, but we used all parts.
Yeah, we made it through all parts. I mean,
in 45 minutes, we get all parts proportionally.
Mm-hmm.
So, for instance, the passion question. I couldn't ask everybody, but
popcorn.
Yeah, but we did enough, so we got all. So if you haven't gone to Vordar College, go to Vordar, go to Advanced Vordar. Everything, they're all fantastic. So yeah, the pyramid, one good story about the pyramid is, so all during the trial, we had both CSS Corp, the parent, and Glow Networks the whole time. All the paperwork either is just CSS, or if it had Glow Networks, it had Glow Networks and CSS. So they were intertwined all the way through, and we argued it was an integrated enterprise. And at one point, we'd just drawn on chart of the pyramid. We kept doing it over and over. The other side objected and said, you need to draw 2 pyramids, one for the parent company and one for Glow Networks. And so we even had to go up and have a sidebar, a big discussion, and the judge was saying, I think you may need to draw 2 pyramids. This is my demonstrative, Your Honor. The other side can draw their own pyramids. Get your own tots. So
when I was doing it, they didn't like our demonstratives, the opposing counsel. And so one of the objections really was I was writing things down. And then when I was writing things down, the jury was writing things down. And the opposing counsel was we had to walk up. I'm crutching up to to the judge's bench. We're going to have our little objection to my demonstrative aid. And she says, Your Honor, the jury is taking down what Miss Sanford is writing on the Elmo. And I was like, yes, well, Your Honor, the jury can write whatever they want. I mean, you can write your own things. Anyways, we had to make copies and give the other side the copy of all of our demonstrative aids. They didn't like it. They didn't end up using them, but they were very upset with our demonstrative aids.
Yes. So it's nice to write down stuff as people are testifying, either on a chart or a piece of paper on Elmo, the important stuff. The jury sees it it's important. And so it's good. And they're with you and you can kind of see what they're doing. So anyway, the end of that story is I got to stick with one pyramid. I said, well, look, I'll explain it that it's from the top down I explained it, got to keep the one single pyramid. However, at the end of the trial, the last day of the trial, the judge did dismiss the parent company and said we couldn't prove integrated enterprise. And so they were out.
Yep.
I don't think the jury was too happy about that, but
no, they asked about it afterwards.
They asked about it afterwards. So, but getting back to the middle of the case, so we put on.
So it's our expert. And then we had two main employees, a white employee, black employee. And then we put on the corporate representative and the main HR manager. And then we finished off with the rest of our plaintiffs. And then we did before and after witnesses at the end.
Right. So, and we did have there's two bad managers that we did say that we were going to call them as witnesses, but the night before, there was something that I just said, I think we ought to let's don't call them because we're digging holes for them so deep. Yeah. Why call them and sponsor them? We're already digging this grave for them. Really. So instead of me just throwing them in the grave, let the other side throw them in their case in chief. So, and I'm glad we did that.
It was a good call.
So by the time that they reserved their questions for the HR and corporate representative for their case.
So we just crossed these two bad people and then they didn't redirect. They're not try to fix anything. And we just moved on to the next person.
And so we just kept digging and digging. It was great. And with our hits.
When the HR woman manager got up there, she was chewing gum on the witness stand. She was retired. She didn't care about anything. And the jury did not like her.
It was a typical HR. I do everything right. We're above it all. We would never do anything wrong. We don't do anything wrong.
Or is white.
She's white, blonde hair. So very, you do employment law, the kind of the typical HR person. So the second in command HR person was the corporate representative at the place. He was black.
Yeah.
The highest black person in the company was second to.
But at the time of when all this was happening in 2015, 2016, he was a low level HR person.
Yeah. So, and he was kind of a know nothing, right? I don't know. Although he was really. So so BB had a really.
I want to tell it.
Okay. It starts out and at the end. Yeah. Okay.
But am I allowed to say the when? Are you ever allowed to, or no?
Yeah. Okay. I think you can.
So at the very beginning, the first question is, when is it ever okay to discriminate based on race?
But you set it up.
Oh, yeah.
You just she went right up there and says.
I copied this from Dawn.
Yeah. So so I don't. If it's secret sauce, it's public record. But this is. So she gets up there and she says, "I'm just going to cut to the chase. I'm going to go right for this is what this case is about. Are you ready for this question?" Yes. All right.
Now, when is it ever? Now, okay, I'm going to stop right there. Now, do you understand what when means, right? Okay. And is it ever, right? You know what that means. Okay. So when is it ever okay? Okay, you understand what okay is, right? Okay, good. So when is it ever okay to discriminate? And you know, because you're an HR representative, that to discriminate means to treat differently, right? Right. Okay. So when is it ever okay to discriminate because of race? Never. It's never okay.
And then we get all of our hits, and then she ends with, and we got this from a focus group.
Oh yeah. Okay.
So we got a focus group. We're saying, well, where does the buck stop? Does the buck stop? Where does it stop? Does it stop with HR? No. Does it stop with the bad manager? No.
Okay, well, sort of. Yeah. Okay.
Finally, one.
Well, no, okay. So it starts off like, okay, so if this is all happening and the employees are complaining to their supervisors, well, if their supervisors are the ones that are actually doing the discriminating and the retaliating, who do they go to? Where does the buck stop? Right? Okay, well then I guess the manager. Okay, if the manager does nothing, where does the buck stop? Well, HR. If HR does nothing, where does the buck stop? Well, then it goes, eventually got up to the CEO of the company. And if the CEO of the company does nothing, where does the buck stop? He thinks about it and he's like, well, our justice system. What does the justice system in America look like? Where does the buck stop at the justice system? And he pauses and he looks at the jury and he says, the jury. And then I passed the witness. It was really good.
It was very powerful. So what I was trying to explain is that we got that idea from a focus group.
Mm-hmm.
Focus group, we were saying, where does the buck stop? And one strong African-American says, I'll tell you where it stops. With us, right here, it stops. As if he was on the jury already. We thought, man, there's power in that, right? So as you know, EDGE empowers the jury.
Yeah.
So we're constantly empowering the jury. We also had a theme with our theme was our country was founded on equality. That's who we are in America.
Have you ever heard, we hold these truths to be self-evident, that all men are created equal? Have you heard that before?
That was a theme as well. So that's who we are as Americans. It's foundational. So we kept that through there, and the system failure to supervise, failure to monitor. Root cause, failure to monitor. System failure was failure to supervise. They saw it all the way through. When they brought back on, we knew that we were winning when they brought back on the HR person.
In their case in chief.
In their case in chief. And by that time, you can tell the jury is upset with them.
Yeah.
And the HR person makes a joke and laughs herself and turns to the jury expecting that they're going to be giggling. They just had stern faces, and she's just like,
they crossed their arms.
And she smiled, just went like this, and she turned back away. Oh my God, So, but I don't think that the other side knew that they were losing. We knew that. I mean, we had a very strong. You never know, of course, until the end. Mm-hmm. But it was like, okay, how much is it going to be? So, so we did not ask for any lost wages. Zero. Most of our guys found better jobs because they were good employees. And the things that they were picking on them for really had nothing to do with their projects getting done. It was, oh, you're on your phone. Oh, your breaks are too long.
Yeah.
Oh, we had some night shift people. Oh, you're sleeping. But all of them got their projects done on time or more.
And they were given more projects than the white and Indian employees, and they still got it done. They
still got it done. So it was all around the edges. So then the closing,
mm-hmm.
So I'll tell you, I've been to advanced closing. You need to go to advanced closing. Very powerful stuff. So the one thing is the night before I was going to give a number, $1 million for each. And I thought, I'm just going to say, you decide. You decide, ladies and gentlemen, you decide. So I didn't ask for $1 million. So anyway, we
didn't ask for a number.
I didn't ask for a number. We only asked for mental anguish and punitive damages, right?
Past and future mental
anguish. And the whole defense was two things. They either deserved to be terminated or disciplined, or everybody's going to get laid off anyway because the project was going to end in 6 or 9 months, and it did. So the problem with that is
they brought back, treat them that way?
Yes, no excuse for discriminating in the process. And they brought back a dozen people that were laid off, but not Black.
Asian.
Right? So
well, they did bring one Black employee back.
Oh, they did.
But what they did is he's a really big guy. He used to play football. He's like over 6.5 feet tall, 200 something pounds, huge, deep voice. And he's from like around Compton area in California. He's an engineer and
living in Dallas with a family.
Right? Got kids, got a wife. And they rehire him back and they say, hey, you're from California, right? Like, we have a project out in California for you. He's like, okay. They don't give many details about it, but he's an engineer. He's done this job before, same kind of project. Well, it turns out what they hired him for and what they only allowed him to do was to drive people who came from Asia at the LAX airport, pick them up at their hotel, drive them to the site, wait for them while they did the software engineer things, and then drive them back to the hotel. And he drove them to and from in Compton because they wanted a black man to drive in Compton. He wasn't allowed to do any engineer work at all. He was a chauffeur.
He's
So the
basically a
only
black bodyguard in
black
Compton.
person they rehired to be a chauffeur bodyguard type figure. And it was, when the jury heard that, he was one of our last plaintiffs to go. They were done. I think one like audibly gasped.
It was hard corralling 14 people. It was hard getting him there. He almost didn't think it was worth it to come
Yeah, he had to
because
fly.
he had to fly in. He took the red eye that night, and we almost didn't get him there. And he was one of our best witnesses.
Yeah.
So, but here's the fascinating thing that the jury got to see and we got to see is the spectrum of how people deal with discrimination. So we had on the one end these twins, these two guys from Nigeria, and they were like sons of a tribal king there, and they were very proud. And
Yeah.
you know,
Real
they let the discrimination slide for about 2 weeks, and then they stood up and said, "Stop!"
No more.
And of course, they got hit on the head, and they stood up and then went to HR. And thank goodness they did emails. Other people, only one other person did emails, but we had email trail of discrimination complaints, and they would get up and tell anybody, whoever. I mean, they were bold. So on one end, you had someone that's not going to take anything and stand up the minute anything happens, right? They weren't physical, although they tried to taunt them into being physical. And on the other end, you had another one that got up, and very quiet guy, one of our favorite guys, that personality, quiet. And what he would do, he made no complaints. He just decided he was going to work all the harder.
Yeah, he testified, look, when someone's treating me that way, how I've been raised, how I handle it, I put my head down and I work
You just have to
harder.
work twice as hard.
And that's what I did.
That's what he did. And they gave him some award, even though they let him go and demoted him and for working hard. And then you had, everybody in between. And you had the big guy from Compton that when he was there, our guys were so real, right? Part of that was just a witness prep. They had to be authentic, right? They were so real, and they were really real under cross-examination. But although I think this, what I'm about to tell you, is direct, and I can't remember if BB took him or I took him on direct.
I took it.
Yeah. So asking him, so he didn't want to say what it was. So why were they asking you to be basically a chauffeur? Why? Well, he didn't want to say. He said, well, you need to say. He said, well, this is hard for me because
I don't want to play the race card.
I don't like talking about my race. I never want to talk about my race.
Yep.
I don't want to talk about it with anybody. I don't want to think about it. I want to ignore it. I don't want to deal with it. It's something I shouldn't have to deal with, and I don't want to. And he was, at that point, he had his head down as he's talking. He had his head up.
Maybe you did take him. I don't know.
But he said, I got to tell you, there's no other reason than because I'm a black man that they wanted a black man to be in Compton. I mean, it's because I'm black, and their jury's on the edge of their seat.
Yeah.
Listen to each of these stories and seeing the big picture. I mean, they get it. So
That's one of the reasons I think we didn't want to ask for, we didn't know how they were going to rule. Like, how are they going to evaluate one person versus another person and how they dealt with it? And we were really happy that every single plaintiff got the exact same award, because it did happen to them. They all experienced it differently. They all reacted differently, but it was still the same treatment. And you did get to see the spectrum of how people reacted to it, and the jury got it.
Yeah. So in closing, I said, look, they say everybody's going to be laid off anyway. But it's not the fact that they were terminated or laid off or even demoted or promoted. It's how they did it and why they did it. It's the how and why. And that's what matters. All these guys are great guys and they got great jobs afterwards. And that's not what we're here for. So, and then I talked about, so this was a Section 1981 case, 42 USC Section 1981. And unlike Title VII, as you know, Title VII has caps, $300,000 caps for mental anguish and punitive damages combined. Section 1981 is our Civil Rights Act of 1866 that was passed before caps were ever invented or thought about. You know, we believed in the power of the jury. So, but it was our first Civil Rights Act. And so in closing, I said, look, our Section 1981 was passed right during or at the end of the Civil War. When they passed the 13th Amendment abolishing slavery, Congress said, what good is it abolishing slavery if you can't buy and sell property or get a job? So they passed the Civil Rights Act of 1866. It said everybody has the same right to contract in business as white citizens. And so, by the way, that sounded quaint 10 years ago. Now it sounds modern, like that language would be in modern statute today. But and then that Civil Rights Act became the blueprint for one of our most, if not our most important amendment, the 14th Amendment. They used that language as the blueprint, the equal treatment for the 14th Amendment. You can't overstate the importance of the act, ladies and gentlemen, that you're about to enforce, if you choose to do so. And then I said, and our country was founded on this principle. And we had a picture of PowerPoint, the Declaration of Independence. We all know that our founding fathers said, we hold these truths to be self-evident, that all men are created equal and are endowed by their creator with certain unalienable rights. Among these are life, liberty, and property. And then I had a picture of a beautiful painting of Gettysburg war scene. And it said, Abraham Lincoln, in the Gettysburg Address, said, our country is dedicated to the proposition that all men are created equal. And then in our time, and then I have a picture of Martin Luther King. Martin Luther King said, I have a dream that one day our nation will rise up and live out the meaning of its creed. And then we had it there, all men are created equal. So
it's real patriotic. The jury said they were tearing up afterwards.
So then when I went to, massage I was running out of time, the jury charge, I just said, ladies and gentlemen, if you agree that there was discrimination, retaliation, just say yes. I just wrote one yes, just say yes on all these. There's like 40 questions.
It's a rather long charge.
Right. And then for the money, you decide. You decide if it's zero. You decide if it's tens, if it's $1. You decide if it's tens of thousands of dollars or hundreds of thousands of dollars or millions. And because it's punitive damages, I said, you send the message you want to send with the money, because everything's measured the way we measure value in commerce. It's measured by money. So you send the message, you decide. And they were about 3 hours later with 40 questions, came back, everyone was, so the judge, you want to tell the part about the judge?
Yes. Okay. So we have, it's Friday morning, it's now Friday afternoon at 3. So we finished.
Into the second week.
Into the second week, we finished closing arguments around like 10 something, and everyone's coming back at 3 to read the verdict. And so everyone files in. So we have our side, the plaintiff side of the gallery is packed with all of our people. They brought friends and family members. So it's packed, and the jury comes in. They're like, oh, they see a lot more people here. And the foreperson gives the bailiff, who gives the judge the jury, the verdict form. And the judge starts opening back up and looks at it, closes it, says, I'm gonna need 15, we need to take a 15-minute recess. I'm gonna look over this and make sure everything's correct. We're like, oh, okay. So they excuse the jury, the judge goes back out. 15 minutes later, judge comes back in. Judge looks at the plaintiff's gallery, looks at all of our clients and all the people, and he says, now, this is a court of law. And then he also looks at us and addresses us and says, you are not to make any facial expressions. You are not to make any kind of reaction to what's happening. And basically it's just like, hey, sit still.
There will be
Don't
decorum in this courtroom.
Yeah.
And it was the speech.
Gives a speech, and we're like, oh gosh, okay, what's going to happen? So the judge decides not to read it, and he gives it to his courtroom deputy. And so she's reading, the courtroom deputy is reading it. And so all of a sudden, was plaintiff number 1 discriminated against? Yes. Number 2, yes. Number 3, yes. Okay, we're like, okay, this is good, this is good. So then we get to the damages part. All right, what sum of money, if paid now in cash, blah, 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 for past mental anguish, $2 million. Future mental anguish, $1 million. Is there punitive damages? Yes. What sum of money, if paid now in cash? $4 million. And for each person, 2, 1.
Same
4,
numbers all the way
2,
down the line.
1.
By the time
4.
we get to the third one, I'm like tearing up and trying to keep it from choking, and I don't
But we're
want
not allowed to
to
make a
jury,
reaction.
and I'm trying to make a reaction. And then we were allowed to talk to the jury, but the jury didn't matter. They saw us in the parking lot. They all came out in the parking lot and hugged us. So, but they said, Mr. Sanford, we thought you were mad at us because you didn't say anything. We thought you were mad.
And they
Were
came
you
up to
mad?
me and said, was your dad mad about the verdict? His face looked like he wasn't taking it well.
I was trying to maintain decorum. So, no, we're not mad. No, thank you. We love you. Thank you.
He was holding back tears.
I was holding back tears. So,
and they asked, do you want to tell them what they asked you?
what?
Did we pay you? Did we put enough money down?
Oh, did we do enough?
That's what they asked.
So, it was so wonderful. It's just like the stories you hear where they say, look, we are so glad we were on this jury. It changed our lives. Now we love the system, and we were allowed to talk to them a little bit with the other side back in chambers. And guess what they said to the other side? They said, well, anything we could do? You need to put in better systems, and you need to change it.
This is unacceptable.
They got it. It was all system failure.
They say they looked at the corporate representative, the HR guy, and said, you need to go back to your company and tell them that this is not okay and they need to change things.
This is all preventable.
All preventable. And some of them were saying, like, we're hoping that this verdict gets some press, that like other companies will see this and they will be like, this is a warning. We cannot be this way. We cannot treat our employees this way. This is the 21st century, for goodness sake. They wanted to send the message and they said it. We had a question from somebody said
The group. We did witness prep individually. Don't
we did not do it
as a group.
It was too
Even
hard.
though we had 14 people, it took a lot of time. Well, the 14 depositions, or 13 of them, and then we took depositions. That was a lot of depositions. The fact that there was Zoom helped a lot. So, but no, individual, you just have to do the hard work of taking the time to do witness prep for everybody.
Yeah, but it really is worth it.
So we're now
important.
So we're still in post-judgment stages. The judge has not signed a judgment yet.
Yeah.
We've got a motion out there for the judgment. We don't know what's going to happen. We're just going to fight for it, but at least it's, sending ripples and helping people's lives, so it's awesome. We're still kind of, it's hard to take in still. It's still great. What's so great is all the hard work that you do, that all of us do together in our own cases, and that we take to the colleges, the decisions that we anguish over, and the late nights, and wondering if we're doing it right, and if we're doing all this for the right reasons at the right time. And you finally, it turns out okay. We had just lost a trial in December in the same area. and we thought it was a really good
Poured out.
age discrimination case. The jury reported us out in 15 minutes. And then even in their comments, they allowed to have comments later said the other side should get better attorneys, meaning us.
They didn't love us.
So, that's part of it. Once I know how that works is once they make their decision, it's all in one way or the other. But it sure was nice to have that.
So another question, how many focus groups did we do? Probably at least half a dozen.
Yeah.
Start off with neutral narrative. Then we do safety, opening several times. I always like to test out my opening. We
test that out at least three times, and we always test out our opening several times before trial.
Mm-hmm. Test out our questions that you want to do for part of the pie. What trial tech? So we were actually really basic this time with our trial.
Oh, tell them about that.
Yes.
We only used Elmo and a flip chart.
Yeah. And we had hard copies of all of our exhibits that we used, and we just put them on the elbow and we circled it all over it.
We didn't have the boards for the rules because of the supply chain.
Issues.
We couldn't get foam core boards. So
they were out. You couldn't do it. And we decided not to use trial pad. So we were just like real old school, handwriting things out. And the other side, the defense had a tech person. They had one tech person for the first week, a separate tech person for the second week.
Sitting behind a desk.
Yeah. And the second week, the person wore these big headphones and kind of like one off the ear and one on the ear, because there was like some audio files that we were listening to and some videos. And afterwards, the jury's talking to us and they were like, oh yeah, we called their tech person the DJ because of the headphones. And they were like, they needed a whole tech person to come and press one button, because on the podium in federal court, you press one button and it goes to the plaintiff's table, and you can use the Elmo, and there's one you press it for the defense. And so every time it would pass the witness.
Well, they would push a button to put the next exhibit up. So that's all that they did. It's just like, what do you need a tech person for that?
Yeah, when we passed the witness, the tech person would literally stand up, walk to the podium, press the button to go to the defense side screen, and then walk back around. And the jury was like, why do they need to hire someone to do that and pay someone to do that? The DJ. So we did not use a lot of technology for this case. PowerPoint, Elmo. Yeah, we did have a PowerPoint for the opening and the closing, and that was the only time we used a PowerPoint.
Other than that, it was Elmo and flip chart.
Mm-hmm.
So the nice thing about the Elmo is you can be, you can write on a piece of paper your demonstrative if you want to. So you can show your exhibits, but then you can also have a blank piece of paper and just draw your demonstrative there.
Running.
Yeah. So that's what we did. And so we're not, I don't think we're any better than any of you guys. You could have done it with the same case that came in. We just never give up, and we apply and we apply and we apply.
And we took it. I know I at least took this to a college, and it was really helpful getting people's. I think I took it to the employment seminar maybe, or employment college. And so it was helpful to get people's feedback, to work on it.
No, you took it to the rules college. We reworked the rules, or was that maybe a different case?
I don't know. But it was helpful just to have everyone's input and to really talk about it and think through. And so we started edging it from the beginning, from when we first got the case.
Colleges are invaluable because we get input from, everybody else.
Yeah, from all of
you
y'all.
get 6 or 8 people input on those. So can't say enough. So we're about out of time. If anybody has any other questions, I'm sure there's a lot more we could talk about. Any thoughts for how to keep it? So one of the things that we need to do is anybody, I think what we need is to try to find out from anybody in the personal injury verdicts where they've gotten large intangible damages that we can show and compare.
In Bordighera, were people in masks? No, masks were optional. It's kind of northern Dallas area.
Yeah, in Texas, where
COVID doesn't really exist here. So people have to walk up to one. A couple of the courtroom officers, CSOs, marshals, had microphones, and they walked around and each person in the veneer panel had to stand up before they spoke and get a microphone, speak into the microphone, and then give it back. How do we promote crosstalk?
Oh, crosstalk? Yeah, we had crosstalk.
Some of it was popcorn.
Yeah.
You had them call on. All right, so you answer this question, then you pick somebody else.
Yeah. So that was. Crosstalk is very good. We were kind of getting with touchy subjects, like, some we didn't really ask about Black Lives Matters. We did, but because it was a race case, it was coming up, and so we didn't want there to be big arguments in, jury selection. So I stuck to the pie, is what I did. Okay, and when I I don't want to get into to stuff, but I did the best I could with what I was taught, and it worked.
And we had people helping us in voir dire. We had David, Wiley, Amy Gibson, Jim Sanford
came and helped us,
and they were watching the jury, taking notes.
So we split up in quadrants. So BB took one quadrant in the courtroom of jurors, and David and Amy and Jim, and they had their eyes on them when I couldn't keep my eyes on everybody.
Taking notes. They were invaluable.
Yeah,
and
they're awesome. They helped pick all our jurors.
Cool. So.
Okay.
That's it. Anyway, so thanks for having us. Thanks for having us, Jenna. Thanks for listening to us.
Yes.
This is really fun.
This is it's such an honor to be on here. We love everybody.
Yeah. I'm sure we'll see everybody soon.
Thank you, Brian and BB. And thank you to all of you who joined us this week for our episode of Fridays with Keenan's Cutting Edge. If you liked today's episode, please click that thumbs up to feed the YouTube algorithm. And don't forget to subscribe and sign up for alerts so you don't miss an episode. Next week, we will have William Higgins with us. William is going to share about civility and professionalism. This is a topic we all need a refresher on once in a while. It can be difficult in our adversarial system to be civil and professional with the other side, especially if they are true black hats. I can always use pointers on this topic, so I look forward to learning from William next week along with all of you. Have a wonderful weekend, and I'll see you next time.